Welcome to Chapter 4. In Chapter 4, we focus on the legal liability of CPAs. The two primary focuses of this chapter include common law and statutory law. Common law refers to case law developed over time through the decision of judges. The common laws that we talk about are state-specific. Statutory laws, as an example of the statutory law, is the SEC Act of 1933, which are enacted by legislative branches of government. The first question that we need to address is, why is legal liability an issue? The potential liability exceeds that of other professions for a number of reasons. Consider if an auditor issues an audit opinion of a company that has many investors and the company goes bankrupt. The number of parties that potentially suffered a loss due to this audit opinion is significant. Millions of investors, as well as the firm's creditors that are looking for recourse. The amounts from this may be far in excess of the limits of professional liability insurance. Looking at this from the perspective of the auditor, it may be possible that the auditor was wrong and did not perform adequate audit procedures. In many cases, some of the estimates may have been proven wrong. Investors and creditors often argue in hindsight that the financial statement estimates were inadequate or unreasonable. This is somewhat similar to the Monday morning quarterback. The final factor related to litigation has to do with this concept of deep pockets. If the company that has defaulted, and we have angry investors and angry creditors, suing the defaulted or bankrupt company does no good. So in this case, what investors and creditors will do is they will seek out other parties, and in this case they'll seek out the auditor simply because the auditor has money, has these deep pockets, and if they successfully win a lawsuit, there is actually something to collect. Before we go into common laws that we need to become familiar with, I wanted to go through a couple of definitions. So we have a list of definitions here. First is a breach of contract. Simply, we're not performing as the contract states. Notice as we go through this that it progressively gets worse. Gross neglect is an extreme, flagrant, or reckless departure from professional standards. Scienter is an act with intent to deceive, defraud, or knowledge of a false misrepresentation. The other item that we want to make sure that we understand is this concept of privity. This is where there is a specific contractual relationship between two parties. Absence of a contractual relationship, then the issue becomes is, does the auditor owe a duty of care to the injured party? Elements of proof by a client under common law includes duty. A CPA has accepted a duty of professional care to complete the audit. Breach of duty. The CPA has breached that duty when performing the audit. Loss, there is a loss suffered by the plaintiff, and causation. Plaintiff needs to prove that the losses were caused by the CPA's failure to perform adequately. The duty of the auditor is defined by the engagement letter as well as legal considerations. Breach of duty is defined when the auditor does not perform the obligations within the engagement letter or does not meet the professional standards. Now keep in mind that in breach of duty, we're not talking about negligence where there are misrepresentations due to error or fraud that are found after the conclusion of the audit. The auditor will attempt to prove that the losses were not caused by the auditor. The audit was conducted using generally accepted auditing standards. In addition, the loss identified by the plaintiff is not directly related to the actual audit report. Now the issue becomes related to liability. You notice there's two terms here. Proportionate liability. Proportionate liability refers to the liability that is shared by several. The real issue relates to this joint and several liability. I will provide this document as part of the documentation for this video, but notice what the rule states related to joint and several liability. Joint and several liability makes each of multiple defendants liable for the entire of the plaintiff's loss regardless of the defendant's degree of fault. For example, a defendant who is only 5% at fault might end up paying the entirety of the plaintiff's damages, especially if other defendants are insolvent. So the key issue here is that if the plaintiffs are suing because of a loss due to the fact that the company that they invested in has filed Chapter 11, guess what? They're going to go where the money is, and this is the auditor, and using this joint and several liability claim, the plaintiff may in fact attempt to get the entirety of their loss paid by the auditor. Several slides ago, we talked about this concept of privity. In other words, is there a contractual relationship between the auditor and the plaintiff? When we're talking about third parties, the issue is that there is no contract. In other words, the auditor does not have a contract with the investor that is investing in the target company. The issue here is that third parties must establish several things, one of which is that the results of their loss came from the CPA's performance. The CPA breached a duty of professional care. In other words, the CPA did not comply with generally accepted auditing standards, and that the loss of the plaintiff occurred because the plaintiff relied on information that the auditor provided. So with this information, let's provide some guidance on common law cases that drive how states actually view the auditor and the client. So what you see here is we have four cases. The Ultramar's case on the left, the H. Rosenblum case at the right. In the Rosenblum case, a plaintiff can sue if he or she is a reasonably foreseeable third party. You notice the definition of a reasonably foreseeable third party includes third parties whose reliance should be reasonably foreseen even if the specific person is unknown to the auditor. The more conservative case on the left is the Ultramar's case, where the only plaintiff that can sue is one that has established a contractual relationship, in other words, privity between the client and the auditor. Now keep in mind that all of these cases relate to negligence. If the plaintiff can prove that there is gross negligence, or what we call scienter, in other words, an intent to defraud, then at that point, anyone has the ability to sue and potentially win the case. Let's turn our attention to statutory laws. These are laws enacted by legislature, and the two most prominent laws that affect auditors are the Securities Act of 1933 and the Securities Act of 1934. The Securities Act of 1933 relates to new issuing of IPOs. The Securities Act of 1934 relates to the continuation of stock that is in place. You notice that the Securities Act of 1933 is very pro-investor. The only thing a third party, and again, the third party is the investor, not the organization that has a contractual relationship with the auditor. The only thing this third party must prove is, number one, they suffered a loss, and number two, the audited financial statements contain a material omission. The burden of proof on the auditor is that he or she was not negligent. Let's contrast this to the Securities Act of 1934. In the Securities Act of 1934, the third party must prove, number one, the auditor had a duty to the plaintiff to exercise due care. The auditor breached this duty, and the key thing in 3 is that there was a direct causal link between the auditor's negligence and the third party's injury. And of course, the third party need to have suffered an injury or a loss due to the result. Very briefly on other statutory laws, including the RICO Act. RICO Act was established primarily to break the organized crime syndicates throughout the country. The key related to the RICO Act is that it triples the damages in civil cases. It has been used against CPAs who knew or who should have known material misstatements were present in the financial statements. However, this is a tough case. Courts have decided that auditors cannot be held liable under RICO unless they actually participated in the operation or management of the organization. And of course, as we know, that the auditor is excluded from management if he or she is going to remain independent. Let's talk briefly about what an auditor should do to prevent or at least minimize the risk of litigation. Obviously, the auditor needs to place emphasis on complying with generally accepted auditing standards as well as professional ethics. Retaining legal counsel is critical. Maintaining adequate professional liability insurance is critical. And part of the generally accepted auditing standards require that we investigate prospective clients thoroughly and obtain a thorough knowledge of the client's business in the risk assessment phase. The auditor needs to have the client sign an engagement letter at the beginning of the audit, and the engagement letter should clearly identify the scope of the audit to prevent any misunderstanding with the clients. Our job as an auditor is to carefully assess the risks and errors within the organization and to include an assessment of internal controls. We need to exercise extreme caution of audits of clients that have a high degree of business risk as indicated by such factors as financial stress. Clearly, we need to follow the AICPA and PCAOB guidelines in terms of preparing and reviewing work papers. And then finally, it's critical that the auditor receives a signed management representation at the conclusion of the audit before issuing the audit report. We'll talk about this document later on in the course, but the idea is that the management representation letter clearly identifies the scope of the audit and the responsibility of management. So this concludes our fourth chapter. I thank you very much for your time, and I'm looking forward to our next discussion.